Eric is up.
Yep, I'm here, Senator Sears, sitting in my old seat.
Oh, wow. I was looking for you. You're confusing me. I can't see you. You're in the sun.
Yeah, I know. I've got kind of this, well, it might be glare. It's almost like a beatific glow.
Yeah, it's a halo. It's a, yeah, beatific.
Right.
Rather angelic.
Yeah.
It's rather
Yes,
angelic.
that's right.
There.
Yeah.
That's what I meant to say.
Yeah.
Very ironic.
Because I see you've got another place here. You're listed in somewhere else. So
Yeah, I
I'm
can
gonna
put on my
pin you.
screen as well. Should I do that or not? Just probably not, I guess.
Yeah, no.
Probably not, because I think you'll get a, so anyway, let's go back to Eric Fitzpatrick. Eric, last time we left this bill, I think there was general, even though there is a general agreement on the bill itself, but there was general agreement that the section, correct me if I'm wrong, that says Section 1, 1950, 2/3 supermajority required. I think there was general agreement that the committee would prefer something of the nature of 10 or 12, 11 or 12, or whatever if it's a smaller jury than that, an 8, whatever it is, that 1 or 2 people. So I don't think people were comfortable with the 2/3 supermajority required.
Yeah, I think that's the way I recall it as well, Senator Sears. I think you're right that whether or not to adopt the general principle of a non-unanimous verdict was still being discussed, but at the least there was agreement, as you said, that 2/3 wasn't a big enough majority, big enough supermajority. So, for example, something like 5/6. Just throwing it out there. Some people might want something more, but 5/6. So if it were a 6-person jury, it would require 5. That would mean if it were a 12-person jury, it would require 10. But yes, there's variety, as we indicated last time, as to the way other states do it, and that's certainly one of the common approaches in other states.
Okay, I would prefer that approach to begin our discussions this morning. I think 5 of 6 or 10 of 12 is probably a good place to begin.
Mm-hmm.
Yeah, I agree.
Any comments from anyone in the audience who is watching on? And I can't see you because I've pinned Eric because I couldn't see him. So I've pinned the speaker. So anybody, I can't see you. So speak up if you'd like to comment on that change.
If we'd like the comment.
Yeah, anybody
If we'd like
either,
it that way, speak up.
No, if you want to comment.
if you want to comment. I'm
Thank
trying
you.
to see everybody, but I can't. So
I'll tell them I'll text it.
I'll try again. Is there anyone in the audience who would like to comment? Chris Maley, Jennifer McDonald, Wilder White, Wilders, I guess, and Judge Zone. Jennifer McDonald. Yeah. First.
Thank you, Chair. I want to make sure that I'm being respectful of the committee and take comments as or provide comments as relevant to the discussion. My comment being that I don't believe that this discussion of 10 of 12 or 5 of 6, however it may be written, will address the significant concerns that I had in my testimony. At some point, if the committee is interested, I'm happy to address one concern that I did have of the committee with respect to compromise verdicts and whether or not that was an issue in this state, because as I understood that was the concern that I heard from the last hearing or discussion of the committee. So I'd be happy to talk on that at some point if appropriate.
It's very hard to hear Jennifer here in the room.
Can you, sorry, is this any better? I do apologize.
Yes.
Okay.
Much better.
I had my microphone down because this headset is, it's right in my face. And so I was trying to not conceal. So my comment was that I don't believe that even taking this from the supermajority to a 10 of 12 addresses the significant concerns that I had and that I believe Ms. White had shared with respect to deviating from the longstanding practice of a unanimous verdict. I also don't believe that there is a compromise verdict problem in the state, which I'd be happy to address. And unlike what I said about hung juries, where I don't believe that we have any data, we do have data on compromise verdicts that I'd be happy to discuss.
Okay. Go ahead.
So a compromise verdict, if you go on to Westlaw, if there was a search done of motions to set aside the verdict based on compromises, you can actually see how many decisions in the past, 15 years have been set aside on those grounds. The Vermont Supreme Court does have a standard by which they will set aside a verdict. And the definition of a compromise verdict is when some jurors surrender their conscientious convictions on one issue in return for a similar surrender by other jurors on the issue. The threshold issue that they look at, that the court will look at, is whether the verdict, in determining whether the verdict has been compromised, is whether a jury could reasonably have calculated the damage award on the evidence presented. In that instance, a party who believes that there has been a compromise verdict will file a motion with the court, and the court will rule on that. So to determine whether or not, again, unlike hung juries, to determine whether or not there is a compromise verdict problem, as a compromise verdict is defined in the law, it is quite simple. It would simply be a matter of going on to Westlaw and looking at how many decisions have been set aside. Yes, Senator Bruce?
Mr. Chair, if I might.
Yep.
I'm just wondering if it requires a motion. So hung juries, we know because they're hung and everybody can see that they're hung.
Sure.
In terms of compromise verdicts, if someone doesn't file a motion, couldn't there be a pool of potential compromise verdicts that didn't make its way into the Westlaw statistics because no one filed a motion?
So, Senator, I don't think so, because what you'll need to look at, the definition of a compromise, again, is, did somebody surrender their conscientious convictions? But a verdict is not, kind of in very simple terms, problematic if there's evidence to support the jury's decision. So if a party, I think hypothetically, if a party is not filing a motion saying that there is a problem and that they believe that there was a compromise and that the evidence does not support the verdict, then we don't, as lawyers, and I'm not sure that even judges can say whether there is a compromise problem because we're not in the jury room. And I apologize. Sorry, go ahead.
If I could just complete my point then. So you're presenting Westlaw statistics as though that is the cut and dried truth of the matter. But it seems to me that you could have a situation easily where people do go through the motions of a compromise. They're all happy with it. There's some evidence for it, maybe not enough, so that it doesn't trigger judicial review and it doesn't trigger a complaint by one of the jurors. But still you had a compromise that everybody was ultimately relatively happy with, but still represents a compromise. So I'm just saying that I think the universe of compromise verdicts could be larger than the statistics that make it into Westlaw.
So I'll address that in 2 points, and I certainly understand where Senator Bruce you're coming from. First, as lawyers, we can only base conclusions really on what evidence do we have. We do not have evidence of what happens in the jury room unless a motion is filed. So I think hypothetically, certainly there could be that situation that you are describing. We have no evidence of that. No attorney or individual on this panel today could say they have evidence of that. It just doesn't exist. I think the other important part that I want to read for the committee is that there is something, what's called an Allen charge. So there are certainly situations where it is difficult for jurors to come to a decision. And I think the Allen charge illustrates for you what a court can instruct the jury on, and it is in line with what their responsibilities are. And basically what it says is jurors are allowed to re-examine the evidence, and they're encouraged to re-examine the evidence. So in situations where there's a possibility that there could be a hung jury, and a jury, and I have had this situation where an Allen charge has had to be read. The name comes from a United States Supreme Court decision. So it comes directly from there. So in situations where you have a deadlocked jury, the judge will read an instruction, and the instruction goes to the jury. Jurors, it's your duty to consult one another and to deliberate with a view to reaching an agreement. If you can do so without violence to individual judgment. Each of you must decide the case for yourself, but you should do so only after consideration of the evidence with your fellow jurors. And this is the key part, Senator Bruce. In the course of your deliberations, you should not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. In order to bring 12 minds to a unanimous result, you must examine the questions submitted to you with candor and frankness and with proper deference to the regard for the opinions of each other. That is to say, in conferring together, each of you should pay due attention and respect to the views of the others and listen to each other's arguments with the disposition to re-examine your own views. Remember, at all times, no juror is expected to yield a conscientious belief. So the key point there, Senator Bruce, is that and this is recognized by the United States Supreme Court, jurors are encouraged to re-examine their beliefs, and they are encouraged to deliberate and agree with one another. So I think in summary, I want to make sure that the committee understands that there is a distinction between the duty of the jury to, if they cannot reach a unanimous decision, and again, unanimity is required in every single federal court throughout the country, that if you are in federal court and a juror, there is the potential of a deadlock jury and they cannot agree, they are encouraged and instructed by the judge to re-examine their beliefs and see if they can come to a unanimous decision, as long as that does not mean abandoning their convictions. A compromise verdict, as it is defined by the Vermont Supreme Court, is one in which a juror does abandon those convictions, and we have that data. So while there can always be hypothetical situations, we have no evidence of that. And I will venture to say that a 20-year-old report and committee suggesting that there is an issue with compromised verdicts is both outdated, and I do question whether that was based on evidence. It may well have been, but I would suggest that for today, we can certainly go through and see whether or not we have a compromise issue and tally that up and look at the case law.
Okay, well, thank you. It's consistent with your prior testimony. Appreciate it. Wilda, did you have a comment on this? And then Chris Maley. You're muted, Wilda.
You know, my position has been that to retain the unanimous requirement, because I'm concerned about those voices in the jury room that don't get to participate because they are a minority view. And even though I think there are good arguments on both sides, like, you know, maybe we don't want unanimous jury verdicts because of whatever reason, you know, I think that there are enough safeguards in the law already to guard against the compromised jury verdicts or, you know, the prejudiced juror. But there are no safeguards in the law to preserve the voice of every single juror accept the requirement of unanimity, which is why I come down on the side of requiring unanimous verdicts, because it's so important, particularly for those jurors who are not part of the dominant culture. It's so important to preserve their right to a vote during jury deliberation.
Thank you. Chris, was there any questions for Wilda? I appreciate your position. I sincerely, but my internet's unstable. So Chris, go ahead.
Thank you, Senator Sears and other members of the committee for allowing me to speak. Just in response to what Attorney McDonald just said about the lack of evidence of compromised verdicts, with all due respect to her Westlaw searches, Justice Dooley disagrees, Justice Carroll disagrees, Judge Coopersmith disagrees, other judges on the committee disagree, Judge Pearson disagrees. There were 20 members on this committee, including attorneys on both sides of the aisle. And what they said was, of the three problems related to unanimous jury verdicts, they're most concerned with compromised verdicts, which this committee believes have been a significant problem in Vermont. Judge Katz actually went into specifics about that, so he was a supporter as well. So I guess don't necessarily take my word for it or Attorney McDonald's word for it, but I think we should look to what the judges have said from Vermont. And 20 years ago is not going to change the fact that the system remains the same. It's not going to change the fact that we're in a more polarized society where the dissenting voice is the problem. I want to make clear that the goal of this law is not to drown out anybody's voice. It's not to make a jury verdict easier. Deliberations are supposed to be hard. They're supposed to be fought. Everyone's voice is supposed to be recognized. And those 40 states that have less stringent standards than us allow for such a vigorous deliberation to occur. So when we talk about compromise verdicts, we're not talking about verdicts that are easy. Those are illegal verdicts. When we talk about even verdicts in a non-unanimous setting, we're not talking about verdicts that are easy. We're not talking about someone who's not able to speak. And I would just ask the committee, why is it that the organization that represents people of color, represents individuals, represents women, represents people on the margins are in support of this bill? And the folks that represent the moneyed interests are against it. What I'd say is, when I talked and I spoke about my client Halima last time I was in front of you, when I asked her, does she have a greater concern of there being a Muslim Black woman on the jury who is drowned out in the jury discussion, or of an inherently racist or biased person who then drives the verdict? See, what we're saying is 1 out of 12 persons, not only are they heard, they can then drive the verdict. They can then change the verdict themselves, one person, which is not an American way to make a decision. And so on the issue of compromised verdicts, the idea that motions to set aside verdicts are data for that, I'd strongly push it back against that. We don't know all that happens in the jury deliberations. Judges have a better idea than we do, the ones that are saying that's a significant problem. But we do know that the lack of hung juries are an indication that there isn't the main holdout who's allowed to voice their position. Someone's brought along. Someone's not following the judge's instructions to have so many unanimous verdicts reached. So what we're saying is a compromise verdict is when jurors are listening to what the judge says. The judge is saying you have to do X, Y, and Z, and they are compromising the law. They are rendering an illegal verdict because they are not following the judge's instructions. And that's exactly what Judge Katz said in his committee report from 20 years ago. So we're just echoing a report that's in existence. I know a lot of times your committee has to make decisions and you say, we don't have a report, we don't have data, we don't have information. Well, here we have the Supreme Court saying that this is okay, or members of the Supreme Court anyway. We have judges saying that this is something that should be done. You have a report that is has more authority to it than most of the time when you're making decisions. So we are okay with 10 out of 12, our organization. We think it still meets that goal of preventing one or two lone voices from taking over a verdict, holding it hostage, saying, I am not going to vote with you until you do X, Y, and Z. That is accomplished by a 5 out of 6 or 10 out of 12. So we're supportive of the change that you guys are considering. But this idea that we can do a Lexis search to find out about compromised verdicts, I would push back against them. What those decisions are is when there's actually medical care provided and evidence of suffering, and a jury awards $0 for pain and suffering. So they could not have followed the judge's instructions. But everything else is colorably within the jury instructions. So those compromised verdicts are buried. They're not subject to decisions in the law. I can only think of a handful of decisions where the judge is turning the jury's verdict away in a civil case on these issues. But that doesn't mean that it's not a problem, as those who looked at this suggest. And I'm happy to answer any questions.
Okay. Thank you. Are there any questions? I'm reminded by I realize the study is 20 years old. It doesn't mean that it's not valid, but I'm reminded by the conclusion of the study that in most respects, the jury system continues to work well in Vermont and remains a critical part of our overall justice system. Like any institution, however, it requires periodic examination to determine where the changes in structure or procedure will enable it to work better. The Committee on Jury Policy has identified a few instances where reform is desirable to allow less than unanimous verdicts in civil cases, to reduce the availability of preemptory challenges in all civil cases and most criminal cases, to liberalize for challenges for cause, and automate and expand jury source lists, increase the representatives of juries. These reforms will enable the system to fully meet the expectations of Vermont citizens and produce democratic justice. And I would remind anybody who's looking in on this is only in civil cases. It does not impact criminal verdicts at all. I did get a few emails concerned about criminal cases, and this bill does not impact criminal cases. So getting back to the, are there any questions from the committee or anyone else who wants to? Jennifer, do you want to? Yeah, okay.
Thank you, Senator Sears, and I see that Ms. White also has her hand raised. Again, and I apologize for going back and forth, but this is such a critical issue, and we're talking about changing over 200 years of the jury system. I don't disagree that we do need to regularly re-examine and ensure that the system is serving the people of Vermont, and I certainly support that. I will say I disagree that a 20-year-old report should guide the judicial system in 2022. Many of the individuals on that committee are no longer practicing either as judges or attorneys. So in moving forward, if that report is something that the committee thinks is really critical, it should certainly be updated to be current with the situation that we're seeing today. 20 years is a long time. There has been so much that has changed in that period. So many developments in the law, so much progress. It absolutely should be re-examined if that report and those conclusions carry any weight. I will also say that although Vermont has not updated its examination of the jury system in 20 years, as I mentioned in my previous testimony, the ABA has, and the ABA's position was to continue unanimous verdicts. Finally, I do want to address certain points. I want to make it clear that I don't represent moneyed interests. That I'm not sure where Attorney Maley gets that from. I think that we should leave those sort of statements out of this debate. That is not how I'm coming at this. I am coming at this from a point of view of wanting to ensure that every single member of the jury has a voice. I certainly share concerns that there would be an individual with, as Attorney Maley said, with racist views on the jury. That is certainly concerning. And again, we do not have evidence that that is the problem on our juries. I will continue to cite to the Ramos United States Supreme Court decision. I also circulated an amicus brief from social scientists who looked at jury unanimity in 2020 and addressed this very issue both in criminal and civil juries, and we simply do not have evidence to support the concerns addressed by Attorney Maley. So in closing, I would encourage the committee, if it is going to move forward with re-examining a long history of unanimity in the state, that the report from 20 years ago has to be updated to ensure that it is consistent with issues that we are facing today.
Thank you. I wish we could stick to that for us, which was, should it be a supermajority or should it be 10 to 12? And there may be issues with the bill itself, but I haven't heard anyone comment on that part of it yet, which is what I was asking for comments on. And so it's a little frustrating. We certainly know there's opposition and so forth, but do you have any comment on the difference between supermajority? And I understand you're opposed to the bill, but I wonder if I'll give Walter a chance to comment.
Thank you, Senator Sears.
Yeah, okay.
I didn't state my name and appearance for the record previously, and I want to do so now. My name is Wilda White, and I am the founder of Mad Freedom, an organization that advocates on behalf of people who are discriminated against based on their perceived mental illness. And I also practiced many years, decades, as a plaintiff's civil trial lawyer, and practiced in California, New York, and Massachusetts, in all federal courts. And so I practiced where there were non-unanimous jury requirements as well as unanimous jury verdicts. And I don't understand Krista Maley's reference that people who are opposed to the bill are representing moneyed interest. I certainly don't. I represent people who have very little access to justice. And what I'm trying to do is strike a balance between all the issues that have been raised in support of the bill and also the issues that have been raised not in support of the bill. And I come down where I come down because of all the safeguards. But to your point about unanimous verdicts, whether we should raise the 2/3 to greater than 2/3, of course, Mad Freedom's position is that you should, that 2/3 is definitely too low. But again, it's hard to talk about raising the 2/3 up when you're opposed to the bill. But our position in the letter that we wrote was, yeah, 2/3 is definitely too low. I practiced in jurisdictions where it was at least 83%, or in California, which is a little lower than that. But that's better than 2/3. And the final thing that was really persuaded me on this bill was the experience that I heard a juror say when she was polled whether that was her verdict, where she said that the jury, once they got 9 votes, they just stopped all deliberations. And so she never got her questions answered. And so that's why I think it's so important to actually retain unanimity, but if not, to get those numbers up so that more voices are in. More voices, if not every voice, is a part of the deliberations.
Thank you.
Thank you, Senator Sears.
Anyone else? Okay. I'll go back to the report, even though it is 20 years old. It's still a valid report in my mind. But be that as it may, can we go back to the question for the committee? What would you prefer to have besides the 2/3? And so we can give some direction to Eric. Senator White and then Senator Baruch.
I would prefer to have 5/6. So that would be 5 out of 6 or 10 out of 12.
Okay,
I feel the same as Jeanette.
okay. I'm good with that. Alice or Joe, do you have any comments on that?
I'm opposed to it.
Opposed to the bill, but
I'm opposed to both of those. I mean,
Okay.
yes, I certainly want the 9 out of 10 or 5 out of 6, but I don't want that in any way be construed that I support getting away from 12.
okay, I appreciate that.
Ditto for me.
Okay. So, Eric, if, I don't think it's much to redraft to what Senator White just recommended.
No, it's certainly not a redrafting project, no.
Have I got it right that 40 other states have non-unanimous verdicts in civil cases? Is that correct?
I don't think it's that high, but it's certainly a majority.
What about our surrounding states? Does anybody know?
New York has non-unanimous verdicts. Massachusetts has non-unanimous verdicts. New Hampshire, I believe, has non-unanimous verdicts.
Thank you. Chris?
And Your Honor, you heard testimony from a Maine attorney who went into length
Yep.
about compromise verdicts, but also the fact that their system was 2/3 in Maine, and that it's just a given and understood, and there hasn't been a problem about it.
Thank you. So. Anything else? Senator White?
Do you want us to make our comments? Are we at a point where we're going to make a decision?
I think we are.
Okay, then I have some comments I'd like to make.
Okay, please do.
So I respect Wilda's position here on that there might be minority voices that are just discounted when there doesn't have to be unanimity. But I also understand that, and I do think there has to be unanimity in criminal cases, absolutely. But I also understand that, and I don't know how we get at this whole issue of a compromise verdict and abandoning my principles and stuff. I will tell you that if I've been sitting there for 4 days arguing and somebody says, well, just do this and then I'll agree. Don't give the person, don't recommend $20,000, recommend $10,000. I'll say, oh my God, I got to get out of here. I cannot stick around for the next 6 days and argue with you. Let's just do something. So I don't know that that's abandoning my principles or whatever the term was that was used. But I can say that I think that there are times when this should happen. And may I read something from that I received from somebody that many of us know, and many more of us know her mother. I received this from Vanessa Cattell. Can I just read a little bit of what she
Sure.
wrote me?
Yeah, yep.
Jury trials are sacred. They are the pathway to justice, but the process has to be fair. Most states use a non-unanimous standard because it prevents 1 or 2 biased jurors from having too much control. In the civil jury room, a party should prevail if they are able to convince almost all of the jurors. Without this change, the insured party can end up with no ability to recover. Right now, what is real for injured people is that prior to civil jury trial, we must go through mediation. At mediation, my clients are told by the mediator that the defense only has to convince 1 juror to vote against them. As a result, too often, the injured party knows that this low bar of the defense only having to convince 1, while the injured party, the plaintiff, must convince the entire jury, is unfair. The injured party is forced to take a compromise settlement. The result is cynicism and apathy for our civil justice system. when they feel they have no chance at recovering in this system. Much like in the committee process at the State House, we know dissenting voices can be heard in the deliberation process, but they should not control the outcome. At the end of the day, the civil jury process about fairness for the parties, not about a feeling of inclusion for all the jurors.
Wow.
So I started off not agreeing with this bill, and I've ended up voting for it. I'm going to. Thank you.
Mr. Chair.
No.
Yeah.
2 points. The first is that I continue to believe in a unanimous 12-member jury verdict for criminal trials, because when the state is attempting to punish someone at that level, to deprive them of their liberty or to apply some other very serious penalty, I think that that's a bar that needs to be preserved. When you're talking about a civil verdict, in terms of whether someone has been injured, whether they deserve compensation, I think it's fundamentally different. And just to speak to the idea of jury members having a voice and being heard, I have constituents all the time who will want me to vote a certain way on a bill. I listen to them, I read their emails, I respond, and then I vote the way I'm going to vote. And if I don't vote their way, they often accuse me of not having listened to them or not having heard them. And being heard and being listened to is not the same as getting a certain outcome. So, you know, Mr. Maley made the point about the way we make decisions in America. It is often the case that when you vote, you don't get what you want, but you get to vote. So all of these jurors will get a vote. It's just that we will have a standard that is non-unanimous and they may not prevail. But that doesn't deprive them of a vote on the jury or a voice on the jury.
I think, you know what, I'm sorry to keep coming back to an old report, but to me it remains valid, simply because the voices in the report are people that I've either known or worked with or confirmed or done with. But I noticed that Judge Zone is here, so I would like to give him an opportunity if he has any position on this, or the judiciary does.
It's a good time to run, Judge.
I have to smile because I had just gotten a phone call from a representative in another committee meeting who had a question, so I apologize. Tom Zone, Chief Superior Judge. The determination as to the ultimate 178, I know Senator Sears, before you were asking about supermajority and the numbers. If I can just tell you that I think it's what I used this morning in our earlier meeting. It's a policy determination for the legislature to determine whether you want to go with non-unanimous or unanimous. I sent out S-178 in its original iteration to a number of judges who do civil work. No judge has reviewed that and said that they agree that we should have non-unanimous verdicts. The judges who received that, active judges right now, their view was that we should stay with unanimous verdicts. You've heard the policy arguments back and forth. I'm not going to repeat them here. I note that some of the judges referenced Ramos, the case that has been referenced today, as well as other studies. I won't get into that. You've heard a lot about that when you're going to make your policy decision. But as far as the judges today, I did not hear any judges who received and reviewed that, who are doing civil work, indicate that they believed that we should go to non-unanimous verdicts. That being said, if the legislature decides to go in that direction, I would go with the higher numbers for the supermajority. I would recommend that.
Thank you. Thank you. So Eric.
Are we still taking comments, Senator Sears?
Yeah, please.
What bothers me about where we're heading with this issue right now is almost a complete absence of data collected from jury situations. Every jury assembled ends up with a foreperson. The foreperson is given instructions about how to conduct deliberations. I think any decent foreperson would give every person sitting in the room an opportunity to express themselves. And while every meeting of individuals has somebody that's dominating the conversation, at the end of the day, most meetings end up with a consensus as to how people should go forward. But this committee has traditionally bent over backwards getting reports from every possible quarter and trying to analyze data in a way that we end up making the right decision. I haven't, in my 38 years, had any situation where I felt somebody on the jury got their arm twisted in some fashion. I have a concern that we are simply going to do something because other states have done it. And that leaves me scratching my head. You know, in 30 states in the United States right now, I can ride around with my bare head on my Harley. There's only 20 that say otherwise. If we were doing legislation like that, then I don't understand why that's the case. But suffice to say that right now, I feel like we're looking at a bill without the kind of data that I would like to have. And we have the ability to get that data if this is that big of a concern. Why wouldn't we be asking for surveys to be taken of jurors to determine whether or not there's actually a problem inside the deliberation? Why wouldn't we be asking for current judges to talk about the problems that they're seeing? When jurors are polled at the end of a trial, and it's been 30 years since I've done a civil trial, but I'm assuming that jurors are still polled if requested by counsel at the end of a trial in a civil case. Why aren't we hearing reports about frustrated jurors? I respect Chris Malley. I've known you for a long time. My thought process here is we are in search of a cure to a problem that we're not really familiar with. I understand that there is some frustration, but if you're going to make a move that disrupts 200 and however many years worth of jury work in civil cases, I sure as heck would like to have a lot more information than I do right now. So with that, I am comfortable saying I would agree for an amendment to bring it up beyond 2/3, but I'm still opposed to the bill in toto for all the reasons I just stated.
Appreciate that, Senator. Really respect your voice and your opinion. I've been, I wouldn't have introduced the bill if I hadn't been convinced that it's something that could change. I've only had one experience in a civil case that was against me. I was the defendant along with my then business partner, and it wasn't a pleasant experience. But I will say that in my case, the jury was out for 45 seconds, I think, total. And that included the time it took to walk to the room and back. So it wasn't that controversial, but nonetheless, it cost me $22,000. And if I put that into, this was in the 1980s, so put that into the current value. You lawyers are not cheap.
I appreciate that, Senator, and I'm reminded of my first conversation with you when I was a brand new lawyer, and I had a client down at 204 Depot, and I called down to speak to somebody there. I believe I got you on the phone.
You did.
You scared me at the time, quite frankly.
Oh my God. No, I'm just a teddy bear when it comes down to it.
Well, I've learned that through the years. back then I was definitely intimidated, as I was by Judge Katz, by the way. I cut my teeth with Judge Katz. And, you know, I don't remember anything about the testimony here of Judge Katz actually sitting in a jury and listening to what goes on there. And I think in this day and age, we actually have the ability to collect data from juries. If we're going to make this kind of a change, we should have that in front of us.
Appreciate that. So I think Senator Baruth's, you may not have formally made a motion, but if you would like to make a motion to make the change to either 5 of 6 or 10 of 12. We don't have 8-member juries, do we?
Well, Senator Sears, could I ask a question?
Yeah.
It occurred to me, and certainly I was not a math major, so this is not my strong point, but you could change the 2/3 to 5/6. That's certainly an option. That if the parties had stipulated to a 6-person jury that would require 5, or if it was a 12-person jury, that would require 10. The only thing that occurred to me is, and maybe Judge Zone might have a preference here or maybe not, but you could potentially also say 80%, at least 80%. And 5/6, I did calculate this, is 83%. So if you were to say at least 80% of the number of jurors, that would also mean 5/6 and 10/12 would constitute the verdict of the jury. And then maybe, you know, I don't know if this ever happens. The reason that occurred to me was because the parties can stipulate under the rules of civil procedure to a lesser number of 12 than they would want. And they probably aren't going to stipulate to some number like 8 or 7 or something like that, but perhaps using 80% rather than 5/6 would be an easier calculation if for some reason the party stipulated to an unusual number. That was the only thing that occurred to me. As I say, it's a math issue that I don't pretend to have any expertise with, but it occurred to me that might be an option.
All right, that may make more sense to do it. Is that okay with folks to do 80%? I think that's a good idea, Eric.
Fine with me.
All right. So the motion is to amend the bill for an 80% verdict, or 8. The wording would be, unless the parties stipulate otherwise, a verdict or finding agreed to by at least 80% of the total number of jurors serving on a jury in a civil trial shall be taken as the verdict or finding of the jury. Am I correct on reading that, Eric?
Yeah, you got it, Senator Sears, exactly.
Okay. So the first vote is on moving from 2/3 to 80%. Is there any further discussion? If not, Peggy, could you call the roll on the amendment?
Senator Benning,
Yes.
Senator Nika. Yes. Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears.
Yes. So the bill has been amended. Is there a motion to report the bill favorably as amended in draft? Would this be 2.1, Eric, or 1.1?
1.1.
In
Because
draft
this
1.
would be a strike all amendment, wouldn't it be 1.1 of the amendment?
Okay. 0.1 would be the amendment, and it would simply change the 2/3 to 80%. Is there any further discussion? Senator Baruth has moved that we report the bill favorably as amended. Is there any other discussion? Hearing none. Peggy, would you please call the roll?
Senator Benning,
No.
Senator Nika. No. Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears.
Yes. Would like to report this. Okay.
Senator Bennington, did he say?
I said Senator Benning.
Yeah.
Yeah, well, I don't think so. If you vote against the bill, it's hard to have you.
Doing something
Well,
new.
that is a good reason for voting against the bill, is that you don't have to report it on the floor.
I'll report the bill,
Oh,
but I would appreciate Senator White, while we're giving the report, to talk about, to read that statement you had from former Senator Catel's daughter,
I
if you
I
wouldn't
will
mind.
if you want me to, and I
Well, I
will.
think it was helpful. It's helpful.
Is she a lawyer?
She
What's her
is
shit? Not
Vanessa.
That matters.
She does mostly civil
All right.
trials.
Eric, Eric, are you there?
Yes.
Just wondering if I'm going to be reporting both S4 and S140. So if you could send me whatever you have on those.
Yeah, will do.
Thank you.
We still haven't
As far as a walkthrough of this
Yeah,
bill, Eric,
today.
I don't need much. It's a fairly easy walkthrough. But
Right.
if, Chris, you would provide me a copy of your testimony, would be helpful to pick up pieces. And I
Hi,
invite
it's Judge
Wilder
Levy.
or
It's 11:15.
Jennifer to
I am now
do the
done,
same.
and you can feel free to call me at 802-296.
Judge, you're not muted, so.
Ooh, well, we
Thank
just
you.
got his telephone number.
We got the 802 part, but I think we already knew it was 802.
Everybody got his phone number.
Well, you only divulged that your phone number is 802. We caught you before you
You
gave
called me.
the phone.
I apologize. I had the red light here, but not over there.
Not a problem. I'm inviting, and I'm happy in my report to present the minority point of view as well, if any of you want to send me a copy of your testimony. All right. Why don't we take 3 minutes, not a break, but 3 minutes to just move to the next bill, since Eric has to leave, I assume, and because Ben is the draft person for S254.
3 minutes doesn't even get me to the door.
I know, but it allows me to, while I'm at home, it allows me to move. I need to figure out how much I need to take. And I'm realizing now I got all my files here.
We're still live.
Yeah, I
Peggy.
know.
Oh,
That's okay. I don't mind.
okay. Okay.
We're just taking a short break to transfer to S250.
So Janet is
I'm sorry. Ben, have you joined us?
I don't see Ben.
I can't tell who's next to Alice.
Yeah, that's Ben.
Oh, okay.
You're not needed anymore, guys. Thank you.
Oh, good. I can see, wow, I can see everybody more clearly.
Yeah, how come?
I still like this effect right here. I can put my hand up in front of Alice.
Right.
All I can see is, I can't see Senator. Now I've got everybody, at least who's on the line. Wilda, Senator White, myself, Senator Ruth, Ben. I can't see Peggy. She's over in a corner, hidden.
Right, in my hand, it's behind the bookcase. Oh.
She's hiding behind the bookcase.
See me now?
Yep, thank you. Wow, I'm doubling up on Ben for some reason now. I'm trying a different Zoom thing to see everyone. Anyway, see how that works. Ben, we did embarrassed to say, and you did a terrific job drafting an amendment to draft 2.1 of qualified immunity based on the Zulo case.
Yes, Senator Sir, Ben Obrowski for the Office of Legislative Counsel. Would you like me to share my screen so we could walk through it together, or? would you like to
We
go
could
back?
walk through it briefly.
Bear
I
with
would
me-
like that, thank you.
Bear with me one moment as I.
Would you rather have them share the screen?
Can everybody see my screen?
Yep.
Yeah.
Okay. So draft 2.1 of the strike law amendment to S254 is what's before you now. Section 1, the whole bill has changed quite dramatically. And Section 1 is still an addition of Chapter 190, which would create a private right of action against law enforcement officers. There's now a new Section 5607, which outlines the legislative intent of the law. It now reads that it's the intent of the General Assembly to eliminate the common law defense of qualified immunity available to law enforcement officers in the state of Vermont and replace it by codifying the damages limiting principle espoused in Zulo v. State 2019 BT1 as a burden that the plaintiff must prove to obtain damages in an action brought under this chapter. Moving on to new Section 5608. This is the section of the bill about liability of law enforcement officers, limitations. It creates the private right of action. Section A remains unchanged. Section B now reads, well, changes from before where it just limits the private right of action to violations of the state constitution and the individual's rights, privileges, or immunities guaranteed under the Constitution. Subsection C now discusses how to obtain damages. So this is the burden that the plaintiff would have to prove rather than just eliminating the defense altogether. It's really shifted it to the plaintiff to prove by a preponderance of the evidence to obtain damages that the law enforcement officer acting under authority of the state or within the scope of authority of a law enforcement agency committed a violation of subsection B, which would mean a violation of the Constitution. 2, that there is no meaningful alternative in context of the particular case. And 3, that the law enforcement officer acting under authority of the state or within the scope of authority of the law enforcement agency knew or should have known that the officer was violating clearly established law or the officer acted in bad faith. This is almost a word-for-word resuscitation of the standard that was outlined in the Zullo case, and therefore is now incorporated as a burden that the plaintiff would now have to prove.
Can I ask a question about that?
Yes.
So Ben, in the beginning, it said the violation of a constitutional right, and here it says clearly established law. Is there a difference there?
Well, the clearly established law standard is part of that, is what came out of the Zullo case. So it would be, it would still require that same analysis that we've discussed and taken testimony on about sort of this case that would already exist out there, that would now have to apply in the exact situation before the court. But what it does is that it also provides the alternative of if the officer acted in bad faith. So it would have to be a violation that basically had been adjudicated before, or a finding that the officer acted in bad faith in that case.
But my concern was that it says clearly established law, and when we had the original bill, it applied to all constitutional, statutory, and common law violations. And so this just,
in this case, it just applies to constitutional violations.
okay. And that using the word law there doesn't make it confusing to anybody except me.
Well, just for clarity, it would, in subdivision 1 here, it references a violation of subsection D, which is the constitutional violation. So
Okay.
I believe that gives enough hopeful clarity to that it was a constitutional violation as opposed to a statutory or common law right violation.
All right.
Can I just ask a question? So Zullo right now is where this language has been taken from.
Correct.
Zullo right now is the status of the law. If we don't pass this, Zullo remains the status of the law.
Well, it depends, right? And the status of the law for Zullo, and I know that this has been a point of testimony as well in the past, is that analysis was really limited in that specific case to state trooper. Now, it could be applied in other circumstances. I just couldn't say definitively that it would apply to sheriffs or local law enforcement. But as applied to state troopers, this would be the standard that would apply. The Zullo standard would be.
So
It's not limited to state troopers now if we pass this.
Well,
It specifically expands the reach.
correct. This would be for all law enforcement officers. I apologize for misunderstanding.
So can I ask another question, Senator Sears?
Sure.
So in addition to expanding it to all law enforcement officers, which we've heard would probably apply anyway, but couldn't guarantee it absolutely, but just because of the way the courts work, it probably would be applied to all law enforcement officers, but it also expands it beyond just chapter, in Article 11.
Yes, it would be all constitutional violations.
Okay.
Okay, if we move it forward.
Senator Sears?
Yep.
Sorry, I was muted. Ben, I'm just wondering, lines 18 and 19, well, actually, the whole subsection 3, the law enforcement officer acting under authority of the state or within the scope of authority of a law enforcement agency knew or should have known that the officer, that's the same officer, was violating clearly established law or the officer acted in bad faith. I'm confused by the actual grammar there. Does it mean that the officer was violating clearly established law or was acting in bad faith?
Yes, that the law enforcement officer themselves knew they were violating clearly established law, or that the officer acted in bad faith. I think that's what you're asking, so. Yeah.
Right, so I would suggest that we mirror the verb tense that you have previously in the sentence, so that it would say the officer was violating clearly established law or was acting in bad faith. Because otherwise you've got one in kind of a past progressive tense and the other in past tense, and it sounds very much as though you're talking about two different time frames.
That's an easy change to make. I'd be happy to do that.
Okay.
If there are no other questions, I'm happy to move on to subsection D. So subsection D1 outlines that qualified immunity shall not be a defense to suit or liability available to a law enforcement officer in any action brought pursuant to the state. Basically says it just can't be used as a defense to avoid liability or to prevent or preventing to bring a lawsuit at all. However, there's a clarification in subdivision 2 that the prohibition on the use of the defense of qualified immunity shall not abrogate judicial or legislative immunity in any way, and shall not abrogate any statutory or common law immunity not subject to this chapter. The intent of this subdivision is to clarify that a lot of the other immunities that we had discussed in the past would not be affected by this. It was purely about eliminating the defense of qualified immunity in cases against law enforcement officers, and only under this chapter. Subsection E outlines limitation on damages. So it reads that in any action for damages brought pursuant to this chapter, the maximum liability of a law enforcement officer shall be $500,000 to any one individual, and the maximum aggregate liability shall be $2 million to all individuals arising out of each occurrence. This means that it could be a $500,000 maximum amount that a law enforcement officer would be able to pay for any one person, but if there are multiple people in a lawsuit, the most that the liability would be for is for $2 million.
And can you remind me again where that this is the same standard that's used where?
This is also outlined in the Vermont Tort Claims Act, and those are brought for negligence actions against the state itself. And that would be in 12 VSA chapter 189.
Okay, thank you.
Ben, in the earlier draft, it talked about the law enforcement agency indemnifying the officer. So this language doesn't seem to me to specifically reference the law enforcement agency. Is this now truly a liability of the individual law enforcement officer, or are we talking about a de facto state of affairs where the agency would pick up the tab?
Yeah, later on in the bill, there's the indemnification of the law enforcement officer. This was sort of done as a kind of belt and suspenders, where there could be a judgment against the law enforcement officer, saying that they'd have to pay a certain sum of money. But later on in the bill, and I'll get to it, it does outline the full indemnification by the law enforcement officer or law enforcement agency. And those indemnification amounts mirror the liability caps that we're looking at in subsection E.
Where does,
if I could just
I'm
finish,
sorry, go ahead.
Mr. Chair. So I remember that we had a lot of testimony and a lot of aggressive pushback against the amount in the original bill that was supposed to be picked up by the individual officer, and that was a token amount, as I remember, like $25,000 or $50,000. This increases that 10 times. Senator White, am I remembering that wrong?
No, I think that if you have to read this in conjunction with it was $25,000, but you have to read this in conjunction, I believe, as Ben is saying, with the section farther on that says that there is a complete indemnification of the,
Oh,
so it is
okay.
the law enforcement officer that is being sued, but it's the agency that will pay, I believe, the way
Well,
it's written.
does that mean then that $500,000 is the most that any agency can be made?
For one incident, yes.
Because
That's the same as, and
I'm-
isn't that because that's the same as for claims against the state for in other actions?
Yes,
Right?
that's where the language was derived from, and in section 5610, which I'll get to in a few minutes, that outlines that even though the officer can have a judgment levied against him or her for these amounts, it ultimately is fully indemnified by the law enforcement agency under 5610. So yeah, Senator White said you have to read them in conjunction, and the intent of the drafting here was to make it so that the action can be brought against the law enforcement officer, the judgment can be made against the law enforcement officer, but the payment comes from the law enforcement agency.
Right? Is this part of Zulo?
No, the only part of Zula that's really within this is the standard that we went through previously, those 3 points.
Okay, so if we just wanted to make sure, you said there was question. I'm not trying to get us somewhere we don't want to be, but if you said that there's question, your response to Senator Benning's question was that there's some question about whether Zulo applies to a law enforcement officer who works for a municipal police department or sheriff's deputy or something of that nature. And so if we wanted to just make sure that Zulo applies to all law enforcement officers and leave it at that at this point in time and leave all the other issues aside and try to figure out what to do with them, would we just stop at the end of page 2?
Yeah, I mean, I think what it would do is that it would really end at the in the middle of page 3, right after on line 6. Just if we wanted to maintain the other immunities, but yes, it could be written that way so that this is the standard applied, and then leave the rest to the courts.
All right, just curious. Thank you.
So if there are no more questions, I'll move on to now subsection F. This just reads that the remedies provided in this chapter are not exclusive, shall be in addition to other remedies prescribed by law or available pursuant to common law. So this basically just means that this isn't an exclusive remedy. So if there was a negligence claim you wanted to bring against the state under the Vermont Tort Claims Act, you could still do that. And really what it does is that it gives multiple avenues of redress to the plaintiff. However, if they were successful in any one of those other actions, and they had already been compensated in one, that may be a factor that the court takes into account. So it's not like they can, double dip or things like that. But this is just to say that you have other options as well. And this doesn't foreclose options if you choose this right of action.
Can I ask a question, Senator Sears?
Sure.
So this would mean, out of the same instance, someone else would have options to bring another lawsuit that could go beyond the 500,000 and the person not be taken care of by the agency. Is that correct?
Correct. Same incident, but they could, it would have to be under the facts of those or of that law, of those other laws. So, commonly, what you could do is in a single lawsuit, sue based on, under this law, sue under the Vermont Tort Claims Act. And you can do that all at once. Oftentimes, if you kind of have one shot to do it. But what it is that you can have multiple bases of recovery.
So so in fact, the 500,000 might not be the only thing that the officer would have brought against him in terms of a money claim.
Potentially.
Wait, I didn't understand that. I thought that it meant that somebody could bring a suit against the law enforcement officer and also against the commander and also against the agency, but that the court, if they were awarded 500,000 for one, the court would take that into consideration. And is there still a maximum of $500,000? I mean, could they sue for $500,000 to the law enforcement agency, the law enforcement officer, the supervisor, and the town select board?
Not under just this statute. I mean, this provides the remedy to go after the law enforcement officer directly. If there was some sort of negligence claim as well, and let's say it was a state trooper that was involved, that could be an action that could be brought against the state itself for recovery under the Vermont Tort Claims Act. So, this is sort of saying, and I think this answers your question, is that you can have multiple defendants and try and get recovery however you can. So yeah, potentially against the state, against the trooper. Yeah, you could sue the law enforcement agency itself as well. And those would all play out. This just limits the recovery against the law enforcement officer. And the other statutes or actions that are sued under would govern the other forms of recovery against the other individuals or the agencies or whomever.
Okay,
Oh.
thanks.
Are you finished with that? Can I
Yep.
clarify that further? So I thought perhaps you could give us an example, because I'm not sure. First, I thought, okay, this is the cap on what the law enforcement officer, the amount that could be brought against him or her. But then I thought you said, but other than this issue, this particular issue, what is another example of whereby this officer in particular might have to pay more? And I agree, his agency might be paying it, but what else could he?
Well, so I should clarify that
Individually,
there wouldn't be another avenue for this officer to pay more. It would be, so for instance, again, this would be a constitutional violation. So let's say you're a use of force situation. And someone sued the law enforcement officer because of excessive force, and that was a violation of the Constitution. That claim would be limited by this bill, the 500,000 or $2 million cap. But let's say there was also a negligence claim, saying that the officer acted negligently in some way during that interaction. The plaintiff could also bring a lawsuit under the Vermont Tort Claims Act against the state itself,
oh, okay, no.
and then could recover under that statute. So there are other avenues for redress, but this one is just limited to the police officer for constitutional violations and would cap any recovery under that violation at $500,000.
So say there was also a case of, it was a BIPOC person, and then could that person sue in addition on that issue specifically, in addition to the use of force?
Mm-hmm. And what do you mean as far as
saying that, it was a violation of their civil rights?
Well, civil rights
That would be a federal issue that could be brought against him or her.
Potentially. I mean, and civil rights typically lend themselves to constitutional violations, so it would depend on really what that is. But this is sort of just, I'm using the negligence example, but there are other avenues. I would actually say that a civil rights violation would probably be covered by this, because it typically is a constitutional violation.
It would be included, and it couldn't go beyond the 500,000. Okay.
Hey, Ben, we're running, I don't want to go much we got about 15 minutes left. So
Right.
if we can at least get through the walkthrough of this draft
Sure.
and then see where we go on Friday.
So, yeah, of course.
I feel like I'm
I'll-
running out of time for this bill.
So we are taking it up again tomorrow? Friday. Oh, Friday, okay, thank you.
Well, I'll speed it up. So subsection G.
No,
is
it's not
the-
your fault.
Oh, it's
We've
ours.
got legitimate questions, Ben. You're doing fine.
Well, thank you. I'll still do my best to expedite. So subsection G is the attorney's fees provision that we talked about. The change here, which I think I discussed the last time, is from lines 16 through 20. There's the addition on lines 19, starting that when a judgment is entered in favor of a defendant, a court may award reasonable attorney's fees and other litigation costs reasonably incurred to the defendant for defending any claims the court finds frivolous, which we had before, or brought with malicious intent or retribution for otherwise lawful conduct. This was an effort to capture the concerns raised about frivolous lawsuits and sort of other deterrent factors to prevent plaintiffs from basically levying those types of lawsuits. So this would be things that are brought maybe just intent to hurt an individual financially and really for no other basis, or everything that they did was completely legal, but they still filed the lawsuit anyway in retribution for whatever reason. So again, just more basis for the court to award those costs and fees to a defendant if it finds those things have occurred. Subsection H is the 3-year statute of limitations. 5609 is a notice of claim. This is something that was contained in the New Mexico law, is also present in a lot of other states like New York for any actions brought against municipalities or state entities. So this would be a condition precedent to starting a lawsuit. An individual would have to file a notice of claim within a year of the event occurring and prior to filing a lawsuit. And the notice of claim would have to basically give the outlines of the circumstance. It would have to give the name and post office address of each claimant and their attorneys if they had them, the nature of the claim, the time, place, and manner in which the claim arose or occurred, any damages or injuries that were sustained, and it would have to be sworn by the claimant to say that all of this is true. And it should be served on a law enforcement agency, either by personal service or by mail, to someone designated to accept that service or to their attorney. The intent, and there's also a subdivision here for wrongful death claims, which it gives a little bit more time for the representative of the person's estate to file the claim, and extends it by 6 months, so it would be 1.5 years. But it wouldn't be required if the decedent had already filed the claim before they died. This is serves a couple of different purposes. One is, again, it's to make sure that the claim is real, to prevent frivolous suits, but also puts the law enforcement agency and officer on notice, and that may help with insurance issues and notifying insurance companies and things along those lines. There's also a subsection that subsection E, that a law enforcement agency would have to maintain a record of all notices of claim served on the agency. And then also each record and each notice of claim would be subject to a public records disclosure unless an exemption were to apply. If there are no questions on the notice of claim, section 5610 is the indemnification of law enforcement officers that I alluded to before. This says under subsection A that the law enforcement agency shall fully indemnify its law enforcement officer for any liability incurred, any judgment, any settlement, for any claims arising pursuant to this chapter. And then subsection B mirrors the caps on the individual law enforcement officer, so that the liability of the law enforcement agency would be $500,000 to any one individual, or $2 million to all persons arising out of each occurrence. Subsection C is a mandate for law enforcement agencies to maintain a record of all final judgments and settlements paid for the claims. And again, these are also subject to the Public Records Act unless an exception were to apply. And Section 2 is the effective date.
So, Ben, may I just ask a question about that, about the confidentiality? What if the person does not want the settlement to be known? That's irrelevant, right? It would be public.
Well, I believe that there are considerations in the Public Records Act that could, there could be redaction of names and so personally identifying information. I would have to double check that though. We could also draft in some language to ensure that you could acquire the person's consent or some other mechanism to ensure confidentiality is preserved if it's so wish.
Okay. Thank you.
Can I ask how this impacts municipalities, if at all? I mean, we are saying that the agency, the law enforcement agency, has to indemnify the individual. But is there an impact as a result of that on whether municipalities could also be sued?
No, I mean, this is really just against the law enforcement officer, but a law enforcement agency could be sued. This bill and this law just wouldn't apply in that situation. The only effect it has on the law enforcement agency in this regard is the indemnification requirement.
We have some testimony from the LCT, I think.
Well, I was going to ask Senator Sears, are we going to have witnesses come back and talk about this revised version?
No, we just ignore them all. No, of course we will. I've already heard from people who don't like either, from both sides who don't like this draft. So but of course we will try to hear from both sides, but right now, with the limited time to cross over, we may need to go with a different plan. But I think it was important. I thought it was important for us to at least understand what draft 2.1 was, and at least it was an attempt by me to try to find some middle ground. And given my emails from both sides, I would say I failed to accomplish the middle ground.
I appreciate your attempt.
So I appreciate, I'm grateful to the committee for going through this process. I think we've learned a lot, but I think we have a lot more to learn. But I will say that once I've heard from both sides, they don't like this version. It's probably a good sign that probably not going to fly. So, but I thought it was important to, at least since we put this out to various groups, I thought it was important to have Ben at least walk us through it for the committee. We'll continue to try to come to something. Without going too much further into it, I appreciate the question, Senator Benning. We've been together for so long that I think we begin to read each other's minds, which could be positive, can be negative, right?
Or scary.
Or scary.
I appreciate the comments. When I first looked at it, my initial reaction was that we have actually reversed what was being requested in the first place. And I didn't know, I would very much like to hear from both the proponents and the opponents of the original bill and see what their thought of that is. Putting a cap on the way the cap is worded here had me immediately thinking that J. Diaz would probably come in and say, we don't like that idea. I could be wrong, but that was the first reaction I had to it.
I think you could be right.
Senator Sears, I don't know where you are with the meeting right now. I have another meeting at 12.
I think we have to end very shortly. So obviously we won't have time to hear, and I you know, I do want to go over page 6C. Is there a way to get that information without putting it in the statute? I mean, what we heard from, let me just be totally frank. What I heard from one side was there's a problem. What I heard from another side was we're making huge millions of dollars in payments cumulatively over the last 10 years. I've got examples from Bennington where they've reached settlements with people. I've got examples where the city of Burlington reached settlements with people. I've got examples where the state of Vermont reached settlements with people who believe their civil rights were violated, and obviously there was a settlement. And we heard testimony from the League of Cities and Towns about their insurance policy. Is there a way of getting at this information so that a future legislature would know the scope of these judgments?
Well, judgments and the complaints are all usually public record anyway. The settlements may be subject to confidentiality, so that would probably be a different story. But a lot of times you could access those judgments and complaints from the court directly.
I guess I'm wondering who we get a report from.
We'd probably ask the court.
Ask the courts, but do they approve of the settlements? I suppose they do.
No.
No, there could be confidentiality requirements in the
Right.
settlement itself. But we have spent quite a bit of money on this new Odyssey filing and public portal system that will at least get you the judgments.
Yeah. I mean,
And we might be
But-
able to get an aggregated, like how much has been paid out, even if there are confidentiality requirements for individual
how much has been
cases.
paid out by the
Yeah,
VLCT and how much
Yeah.
has been paid out by the state and all that?
yeah. It's just in an aggregated.
Well, I realize people have other places to go, and we'll pick up with this on Friday morning and try to, yeah.
I
mean,
believe
that's
we're
about
on
all
the
I
floor
can
at
say.
10 Friday.
Hopefully it's 11. I think
Oh,
it's
is it
10 on
11?
the 18th, 10 on the
Okay.
18th and 11 on this
Oh.
Friday. So,
Oh, okay,
I
okay.
will see you all in person.
And tomorrow,
Tomorrow.
here, 9:45.
Right here.
9:45
9:45.
up, yeah.